What's up, everybody? Welcome back into another episode of The Lawyer You Know, the second one today. We've already talked about the Diddy verdict. If you guys want to check that out, broke it down with my dad earlier. Now we are going to watch a very eerie plea hearing, change of plea hearing, where Brian Kohberger has told this court he wants to change his plea of not guilty to now a guilty plea. The state is going to have to provide a factual basis for that. Brian Kohberger is going to have to agree to that factual basis. He's going to have to prove to the judge he knows what's going on, agrees to it, admits that he's actually guilty and did do this, or the judge may not even accept this plea. We're also going to talk a little bit about the inner workings of a lawyer and a criminal defense lawyer and how you handle it when this type of situation comes up, and what, in my opinion, is ethical and appropriate and moral versus what is not, legally speaking. You guys may agree, you may disagree. I'm going to answer your questions. Let's get to it. And I did forget to say, everybody hit that like button if you have not already, to start the video off with a like. I went back and watched some of what Ann Taylor said throughout the case, and my dad was talking about, presumption of innocence, and lawyers are allowed to argue that and should argue that, and they are presumed, and that is legally what's saying. But I do think there are lines in how far lawyers go in saying my client is actually factually innocent. A lot of lawyers do, some don't, some believe it, some don't. In this scenario, I feel like Ann Taylor said that a lot, which I'm going to choose to believe that is what she believed as she said it. And maybe Kohberger came recently and said, I want to change my plea, or I did it, admitted to her. Because I do think that you don't have to say certain things in court. And people can disagree with me, and even some lawyers can disagree with me. You don't have to say certain things, but I still would avoid saying anything factually and in a strong manner that is false or misleading to the court. That is something I think that is a step too far. If you're to say my client is legally innocent, my client is sitting here as an innocent man, should be viewed as an innocent man, is different than I've looked into this case. I truly believe my client is absolutely innocent, and I have to make sure I do X, Y, and Z because an innocent man is going to go to. There's just certain things I feel like lawyers don't need to say and shouldn't say. I do agree, though. People can disagree with me. We can have an open discussion about that. From my perspective, I'm just, bouncing it around how we deal with this situation and how I've dealt with people that tell me they do something or that they admit to a certain crime, and how we deal with it, right? Because that's part of our job. And we don't just go in there and say, okay, lock him up, do your worst. There's a lot you can do even after your client admits to something. There are very appropriate arguments, very appropriate ways to hold the state to their burden, very appropriate plea agreements and resolutions you can get to. So that is something that I think is important for us to think about. And just as I'm working through it myself and just thinking about what she said in the past and how it's going today, and just how eerie this was, the way Brian Kohberger has to go through these factual scenarios and admit to it. And we've seen different reactions and different responses from defendants agreeing or admitting to horrendous crimes. Some, like the eye drop case, they still deny it. Some love it, bask in it, are just sociopaths. Some seem like they're just totally out of it, or they're just taking the deal even though they don't want to, or they feel like they're forced in, or whatever it may be. But this was a different type to me. This was a different type. This almost felt, well, you guys tell me what you think it felt like as we go through and listen to what Brian Kohberger says and how he says it, because it is eerie, for sure. It is eerie. All right. Let's take a listen. So the judge actually starts off with some opening remarks about what's appropriate and not appropriate, and how he doesn't like how certain people in the public have handled this situation, especially trying to get involved in affecting his decision.
Address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Court should, and I always will, make decisions based on where the facts and the law lead me, period. I have not read any of the numerous messages, nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not.
So I get what he's saying. I agree with it. That is not the way for us and the public. And I've talked about this, like, don't reach out to judges. It really doesn't do anything. Don't, write them hate mail or try to influence them or things like that. Having a public voice, talking about it, discussing it with people, voting a certain way, that is what we can do. I think that this doesn't surprise me at all, because he's this type of judge. And he is, what is it? A firm hand, that's how he deals with things. And he's really going to be like, those were all forwarded to security. It's like, okay, you could have just said, I appreciate the public interest in this case, but nothing that the public sends me is going to affect my decision. I have to make my decision based on the law. And what I'm not hamstrung, but that's what I'm guided by. And that's how I'm going to make my decision. So I'm not going to ever be affected by public pressure or comments, but I do encourage the public to speak out and speak their mind. That's probably how I would have dealt with it. He makes it sound like it was this very, nefarious thing that these people wrote in. And he like couples it with, if anybody has an outburst in the courtroom, I'm going to throw you out and you're not going to be able to watch any more proceedings. He doesn't say that, but it's like right on the heels of that. He says he forwarded them to security. You disrupted not only this case, but other defendants' cases. And I get it. And I think it is important for us as the public to understand we should not be doing anything that's going to affect the process in this way, the administration of justice, just because we disagree with something. Same thing if we disagree with the jury's verdict. We shouldn't hammer the jurors. We shouldn't go out of our way to publicly shame jurors or privately go after jurors or dox jurors or things like that. That's what I think is cool about social media. You can put your public thoughts out there and your public comments out there. You can talk about what you think and what you believe. I don't think it's necessary or the best thing to write a judge. I don't think you should write a judge. I think he did the right thing to not even read them, just forward them on to security. They are not anything that has to come into his purview or anything that he has to consider. And people are wild and they say wild things and they do wild things. And there's really no place for that. And when you do, I can understand why people get upset. And maybe I'm just used to it. But I just think that in this process, in this situation, we all have to be careful. And this judge is on the extreme side of careful and saying, like, don't do it. There could be negative repercussions of doing it. And he took as hard of a stance as you could possibly take, which is within his discretion. And that's what he can do. And that's what he chose to do in this case. In the comments he made, I think different judges would have handled it differently. This is his courtroom. This is his case. He handled it the way that he felt appropriate. And it is what it is. I don't think there's anything wrong with his comments. I don't think there's anything legally wrong with his comments. Probably not the way I did it. But from my perspective, those are the comments he made at the beginning.
Not continue to mount such campaigns or to send me information like this, because again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require.
And he's absolutely right. The state's the one that makes the decision to file for the death penalty, not the judge. If the state doesn't feel like they can prove it, for whatever reason, they don't have to tell that to the judge. They make this decision, and we all know and understand that this was never going to be rejected by the judge unless he found that Brian Kohberger didn't understand, doesn't know what he's admitting to. There's a surprise fact in there that he's not agreeing to. Somebody forced him, coerced him. That's the only reason he really is going to reject the change of plea. Not because he thinks a different penalty is more appropriate. He's just not going to do that. He's not going to do that. Energy feels weird in the courtroom. I agree with this. And I've seen and listened to and been a part of a lot of sentencing hearings and change of plea hearings, this one had an eerie feel. That's the way I would describe it.
Require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July.
So that was a really good, I'm glad he did that. I'm glad he gave the explanation as to why this all happened so quickly, because some of the victims' families were upset about it, and I think that that's fine. I think there is middle room for that and middle ground for that, to delay everything a week so that the victims' families can be involved. I think that's worth it. And I think, getting everybody getting into these schedules and stuff is like, this is important stuff. This is important stuff. And if the victims' families want to be heard, I think they have the right to be heard, even if we have to delay the trial a week or cut a week out of a 3-month trial, figure it out, right? Work later during the week. Like, there are ways around having to rush it this much, but I appreciate the fact that he did explain to us why we are here. Diane said, why didn't they make it part of the plea deal that he had to say where the knife is and how and why he did it? It's just not a common thing that's done in plea deals. It's not necessary for a factual basis. It's not necessary for a change of plea. You're not going to blow up a plea deal like this over that, usually. Would love your thoughts on Ann Taylor's smirk. Felt like someone caught off guard and would act differently. Also seemed inappropriate for the mood of the room. It's hard for me to see, hard for me to comment on. I don't know what's going through people's heads. I don't know what they think or mean or feel about something. I usually don't like to guess at that. Bodie, innocent people don't plead guilty at this level. I tend to agree with you. So innocent people absolutely do plead guilty to crimes all the time, but it makes no logical sense at this level to plead guilty to this crime, to get life in prison, which even people on the death penalty, basically a lot of them in Idaho especially, stay there forever and ever, it seems like. So it doesn't make sense at this level for somebody to be innocent and plead guilty, especially the way that Brian Kohberger pleads guilty. It's just, this is not usually what it sounds like. I don't know, right? I'm not going to like get in anybody's head, like I said, but this certainly seems like this dude did it, admits that he did it with every detail and every level that anybody asks of him, and every fact and scenario and situation and outcome and intent. I'm not gonna call him a liar at this point. I'm gonna agree with and believe what he said, because he says it pretty loud and clear. I'm confused as to why Brian Kohberger would do this. It also seems such a quick snap decision. So many questions that now can't be answered. I'll tell you right now, this was not a quick snap decision. It may have felt fast. It may have been to some people like come out of nowhere. This was not a quick snap decision to Brian Kohberger. And the judge is about to ask Brian Kohberger a lot of questions. And we're going to get a lot of answers to, did he have enough time? Does he understand what's going on? What's he actually pleading to? Does he agree with this fact or that fact? We're going to get all those answers. We're not going to get motive. We're not going to get where the knife is. We're not going to get how he did it without DNA X, Y, and Z here and there, although we do get some information about that. We get some details, definitely not all of them. Peter, do you have any opinion on Dr. Catherine Ramsland's recent comments about studying Kohberger? Thank you for your excellent videos. No, I don't really have any comments about that.
With the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible. because of the extraordinary administrative efforts that were otherwise attendant to the process of this getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finished the hearing this morning, I asked that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the defense have reached a plea agreement in this case.
So those were all his opening remarks. What is his role, issues that have been going on, what he plans to do. And he just basically lets everybody know, I'm going to accept this as long as everybody answers the questions appropriately. That was a message to the public at large, to the victims, to the prosecutors, to the defense attorneys, and to Brian Kohberger himself. If we want to get this done, this is how we get it done. This is why we're doing it so quickly. If we don't get this done or it falls through, we're calling everybody back and we're bringing the jurors in. We haven't vacated that trial date as we sit here right now in the real time of the hearing. Could the state of Idaho do the same as the state of Florida did in regards to Danny Rolling trial? I remember the prosecution presented their case in trial format despite his guilty plea. I don't know what that case is. They don't end up doing that. They do not end up doing that. They give a pretty normal factual basis. Is it true that with the mandatory minimum of 10 years per each count in the state, he could potentially apply for parole after 40 years, 50 if counting the burglary? No, this is life without parole. Life without parole. Writ of habeas corpus for ineffective assistance of counsel. Is that what that means? Still available. He's waiving all of his rights to appeal. I believe that would be one that would be waived as well. After watching Karen read and seeing everything here, it seems like the prosecution only wants a win and doesn't want the world to see the truth. Have fun on your vacation. Oh, also, Turtle Boy talked about maybe doing a chat with you. I have not seen that. I'll have to check that out. Listen, I get it. I don't think this is the prosecution trying to hide things. We're going to hear about whether or not or how long the non-dissemination order might be involved in this case and when it might be lifted. I think we're going to get more information that way. I don't think the information is done coming out to us. I think the prosecution, that depends on the prosecutor. Bad prosecutors just want to win. In this situation, they did what was necessary to get what they felt was justice. And I think I've heard the families are split. Two families approve this, two families don't. It's difficult for, a prosecutor to really reject something like this in this situation and go for that penalty. They can. But I don't think we should say one family's right, one family's wrong. Everybody brings their own perspective and different ways of looking at it. They grieve differently. They think differently. They mourn differently. And it's very difficult to put yourself in their shoes to really, I would never condemn the way either of these victims' families feel in this case. But from my perspective, I think that they did what a lot of appropriate prosecutors would have done in this situation, and they didn't do this to hide anything.
For the record, I have a written plea agreement which indicates, in sum, the defendant will plead guilty to all 5 counts in the indictment: burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following: the defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself and be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
Right, very well.
All right, there was a couple questions that were interesting here I wanted to answer. Peter, I'm a little confused why people are upset about 4 life sentences, no appeal, no resentencing. This is more than a lot of families see. Is there something I'm missing? God bless them all. It's just difference of opinion. That's all it is. And I think because some of the families involved wanted the death penalty and said they didn't want to take any kind of plea like this, it is what it is, right? And people are allowed to disagree. Me and my dad broke it down in the last video about why prosecutors do things like this. And a lot of what you said, these guarantees that he's going away forever, protecting the public, saving everybody. Well, I mean, you're losing some money, saving some money with certain appeals and, death row versus life. We can get into that debate, but there's a lot of guarantees in this, and a jury trial is never a guarantee. Peter, have you ever had a client plead guilty at the last moment? Yeah. Yeah, I have. I've also had clients where, I've told them like, hey, this might be something you want to do. And they're like, no. And then eventually they say yes. Sometimes I'm thinking we're not going to do it the whole way. And then the client says, yes, they do want to. And it's the client's decision. It's their life. And that does happen at all different times throughout the process, early on, all the way to late, sometimes in the middle of trial. Home on bed rest, and I'm loving all the live coverage. Love you, Peter. Love you, Papa T. Please cover the Soto case. Enjoy your vacay. Thank you so much. Defense / Kohberger threw every motion they could at the court, all failed. And Taylor finally said, how about that plea deal? It's always been there. I don't know if it's always been there, but they definitely tried to look under every rock before agreeing to this plea deal.
All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
That I thought was something, right? Two seconds ago, she was saying, I need to do this, I need to do that, I need to do this. But you have to agree to this in these situations, right? Or else his rights might not be preserved. Just interesting.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes.
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily. And I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right.
Because everything here is going to be on the record. Everything here is going to be a situation where if at the very end he's like, never mind, and he's already said, yes, I did this, yes, I did that, yes, I'm guilty, those could all come in at trial. Another thing I felt was a little bit strange, and we talked about this with Lori Vallow, with Sarah Boone, and some of the other cases. I don't care about the street clothes. A lot of people ask about the street clothes. We'll talk about that at the end where the court talks about it. But it looks like no restraints. I'm assuming he's got leg restraints on or feet restraints on. If I was the state, I may have asked for him to, come shackled today, because he's literally pleading guilty to 4 very dangerous homicides. They have a lot of bailiffs around. You can see 2 of them just in this picture, but I probably would have asked for some extra restraints now that he's admitting he committed these horrible crimes.
Thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not given before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. And Mr.
Somebody
Kohberger,
said they think he had a shock belt on. Okay. I don't know what the restraints were. It's just visibly, it doesn't look like anything, which I know Lots of times there still is, and that's the whole point, is that visibly doesn't look like anything. Peppy Wood, I agree with this. I also, there was like a comment made by Kohberger's family, like, hey, can we have some privacy or whatever? It's got to be brutal for them too, especially, I mean, I don't know, we don't know. What did they know? What did they not know? But if you really didn't know, and then you find out your son did this, that's tough, man. That's really tough. Hi, Peter. Love having you go live twice a day, especially one with Papa T. I appreciate and enjoy how you explain the legal stuff. Helps it make sense. What's next on the docket? Enjoy your vacation. So we're talking about, we've got Adelson, we've got Corey Richins, we've got Morphew, Soto, potentially YNW Melly. We got a bunch of potential things, but it's open. The docket's open to see what you guys want to talk about. Peter, thanks for 2 lives in one day. I know people are anxious for a motive to try and bring sense to a senseless act, but in my opinion, knowing his motive really won't help. May God watch over Madison, Kaylee, Xana, and Ethan. I do agree. Like, you get the motive, and then how much does it change, right? I'm sure the victims really want to know that, but I don't know. It's tough. It's a tough situation. I think you're right. Making sense of a senseless act is always difficult.
Just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include, on count 1, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
So that's important that he understands all that before saying yes to it, right? Alicia said, Peter, I know you don't like to speculate, but this isn't sitting right with me. In my opinion, it's deeper than just Brian Kohberger. The hearing had a weird vibe. I don't know. Sometimes it's just horrible people doing horrible things. Sometimes it's more, I don't know. After all the pretrial motions, the change of venue, etc., are you surprised by the plea agreement? Is it rare for first-degree cases? Thanks. I mean, it's not rare for a defense lawyer to do everything they possibly can and it ending in some kind of plea or resolution. I am surprised, though, like, to me, pleading to life when you are maintaining your innocence doesn't jive, right? There is some weird interworkings in the background, but it's not the most unusual thing in the world either. If you thought you had a good case, why not take the 1 in a million chance or 1 in 1,000 chance or whatever it would have been that, a jury comes back hung or not guilty to take life in prison. There's just so many things going on in the background and so many different conversations you're having with your lawyers internally as lawyers and with your client. So yeah, I would say I was surprised. Annex, thank you so much for gifting 50 memberships. That's awesome. A ton of new members joining today. Say thank you to Annex if you got gifted one of those memberships.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
These are all the important questions to make sure he's doing this freely and voluntarily, not because somebody else is telling him to, lying to him saying, oh, if you plead guilty to this, you're only going to get 10 years or something like that. That was a promise that my lawyer made to me. I've seen people say things like that before. So from my perspective, these are the questions that answer, why are you doing this? Are you sure you want to do this? You're doing this for the right reasons. And that reason is because you committed these crimes. That is the reason you're pleading guilty.
Are you pleading guilty because you are guilty?
Yes.
That was the big question, right? I didn't even know it was coming there, but it's good timing by me. Are you pleading guilty because you are guilty? Period. The end. No other explanations. No, because you're forced to. No, because you're scared of the, death penalty. No, because you don't want to go to trial. No, for any other reason except that you're pleading guilty because you are guilty.
Or to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead?
By the way, did you have enough time to consider this before pleading guilty? Yes. And that's another question a lot of people ask. Was this a snap decision? Why did he do this? Why so quick? It was not. He admits it was not. He had enough time. He thought about it. That's why he's pleading guilty. Are the suppression motions still valid? I don't know what that means, but if you mean, can he appeal the judge's decision? No. He's waiving all of that.
Guilty.
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory.
And you can see Ann Taylor is kind of changing what's on the computer screen in front of Kohberger because a lot of these documents were already drafted. So he can just say, do you agree to X, Y, and Z as opposed to reading the entire document?
Questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case. Should you not plead guilty, did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you.
I do think this judge is incredibly thorough and he goes through every single thing to make sure Brian Kohberger is doing this freely and voluntarily and understands truly and fully what he is giving up. Somebody said, I read that Brian Kohberger's sisters both were fired from their jobs. Stuff like that happens. And I mean, if they didn't do anything wrong and had nothing to do with it, that stuff really sucks. Can he be prevented from selling his story and profiting from any way? Does Son of Sam law automatically apply? Sorry if this is already asked. I'm sure everyone will be knocking on the prison door to interview him. Everything I've seen about Idaho is, while they might not have a specific Son of Sam law, there are laws that protect victims that they can collect from money that the defendant gets from profiting off their story. Now, I don't know if that goes to the level of making sure the defendant never gets a penny of it. I have never litigated that issue in Idaho. I assume if something like that happens, these families, especially one of them, I think will do everything they can to make sure he does not profit off it. And the damages, the civil damages or criminal restitution that these families suffered is astronomical, that no person should ever be able to afford for their life, the entirety of their life. So if they go the correct routes, he should never profit off this, no matter how much money, if any, he makes off selling his story.
If you didn't plead guilty, let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho.
So this is going to be the first iteration of what the state would have to prove. What is the factual basis? But the state is going to give a longer factual basis later.
With the intent to commit the felony crime of murder. As to count two,
And people were asking, why burglary? What's the burglary? You enter a dwelling with the intent to commit a felony. That felony is the homicides.
the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice of forethought, kill and murder Madison Mogen, a human being, by stabbing Madison Mogen, from which she died.
So he has to agree and admit to those gory, heinous details in order to get this plea agreement. And he does, without issue.
Count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice of forethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice of forethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice of forethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
So yeah, we do definitely find out some interesting new or updated facts. Dora said, yeah, I honestly gave him the benefit of the doubt and people criticized me, LOL. But after today, he did it. It's kind of how it works. Presumed innocent, benefit of the doubt goes to the defendant. They tell you they did it, right? If they get convicted, they legally did it.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogen, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
With no issue, yes. to malice aforethought, doing each of those crimes. I at this point, if you don't want to believe him, it's on you. It's your decision. But when he says it with no issue, no hesitation, yes, he did it. Nobody's forcing him to. He's pleading guilty because he's guilty. I'm going to believe him. That's how I sit here as a human being. That's what I believe. And he deserves every single thing coming to him. All right. Before we get to the state's factual basis, a couple questions. When he was originally charged, I remember hearing judge entered a guilty on his behalf. What did that mean? Is it possible Brian Kohberger might have or could have pleaded guilty immediately? Of course he could have. He didn't plead. He didn't say it with his mouth, but that's equal to pleading not guilty. We talked about that a ton in some earlier videos. It had no legal effect. They tried to act like it did, which that was one of the things in this situation where some things the defense did, I was kind of like, listen, I'm all for a vigorous and zealous defense. You guys know that. But some things they did and they acted like they were, it's keeping some, right open to him and protecting his rights, X, Y, and Z. I'm just like, not really, guys. Like, come on. You're doing what might sound good or look good. Remember when they went back in history and tried to argue something that like Idaho has never done? It's like, why are you guys doing this? For some of the things. Other arguments think they did an amazing job with. And they won some huge, very tough uphill battles and arguments, one of which was switching the venue, which I think was a big change in this case. Do you think the FBI will get involved? BK traveled across state lines? No, I do not. Afternoon question. Will BK have a choice on where he serves his time? No. In my opinion, he needs to stay in Idaho and be in Gen Pop. He will not have a choice necessarily, but he may be put in some kind of protective custody because of the notoriety of the case. Was there a gag order for him? Does that apply to Brian Kohberger now, especially in giving orders, interviews and book deals? No. He can talk. He can give well, I don't know if Idaho allows you, like certain places don't allow you to give interviews in jails and things like that, but he is allowed to talk. He could, write a book, whatever. And hopefully the victims get all that money from restitution, which it seems like Idaho has a rule in place that would do that. Hi, Peter. I want to get my paralegal certification. FSJC has no financial aid for that. Which is better, St. Pete College or Seminole State? I mean, I'm partial to St. Pete College. I took some dual credit classes there when I was in high school. Is it possible there's a bigger fish? Possible. I just don't think so. I don't think so, but I don't know. Peter, do his sisters have a wrongful termination lawsuit in Joy Grease? There's just so many other factors that I would need to know and questions I would need to have answered before I could say that. So no, not necessarily. Laura, would you have represented Brian Kohberger? People ask me this. It all depends on what the meeting is like with the person when they come in here and they call me. Would I represent somebody charged with the things that Brian Kohberger was charged with? Yes, under certain circumstances. But there are circumstances where I would not take this case. And that's with basically every case. There are certain crimes that I do just immediately say no to, and I would never even take the call that my dad would. And my dad would do the consultation on certain cases that I would not. And that's just personal choice, how you feel about it, what you believe is right and true, and where you should spend your abilities and work to help people. So I do think that there's lines for everybody, but these charges are not necessarily something that I would immediately cross out. But on that first meeting, depending on what he said and what he thought should happen from there on out with his defense would affect whether or not I would take the case. Doesn't he have to agree to everything with plea deal? Yes, and he does. Does he tell his lawyer this week that he did it? We don't know. How does that conversation even happen with the attorney? Do lawyers still claim the client is innocent if they tell them they're guilty? So they can say they're presumed innocent or that they're legally innocent. I think it would be wrong and unethical personally to come in and say he is factually innocent. And I know that if he has told you he is not. And once again, lawyers don't have to say certain things. And some lawyers may disagree with me about that, but I think the truth is the truth and candor with the court is candor with the court. And there's attorney-client privilege for a reason. You don't have to come out there and say everything your client tells you. This is exactly where the case will crumble. He agrees he went in with intent to hurt KG and EC, both of which were not to be there. And it's not going to crumble on that. I've been following Soto, but I really don't think it's a good fit for this channel. It's so dark, not really Peter's vibe, and the evidence is pretty open and shut. What will he really add legally? I agree. I remember looking at it a little bit, and I don't know that there is a lot of legal nuance or interesting parts to it. The dark nature, I mean, everything we talk about feels dark. But we'll see. I'll take a look at it. I don't know if it's going to be one that we pick up. Okay, so here's one of the big parts of this plea hearing where we hear the state's factual basis.
Thank you, Your Honor.
Your Honor, the organization of the resuscitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on
I say they could never really prove contact with the house or anybody in the house, which is interesting. And I think that was going to be kind of a big thing the defense played on is lack of motive, lack of connection. Why would he do this? Makes no sense. There are maybe some all the other perpetrators or alternate people that we can point the finger at that do have connections and more of a motive. I don't know, but that's why you don't need to prove motive.
August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on Moscow Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Brian Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately
By the way, there's a little echo here with Bill Thompson explaining this. It goes away in a second.
4:48 a.m. on Sunday, the 13th of November. The state's evidence would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow. It would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. The defendant entered the residence, went to the third floor, and with a knife, killed Madison Mogan and Caitlin Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body.
For whatever reason, right? That was potentially the biggest piece of evidence that hooked Brian Kohberger.
And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the 3rd floor. It was on the 2nd floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in her bedroom, and the defendant killed him as well with a large fixed-blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with black balaclava on, holding some sort of container in his hand. And she saw him.
So that was one of the big things I noticed as well. DM saw him leave with a container. And is that how he was able to get out so clean? Did he change upstairs before coming downstairs? Is that why he didn't go after DM as well? Because he had already taken his clothes off, put him in the container. There's just so many different elements to this that are unknown. And I really think that from my perspective, it is part of this story. It is part of the Brian Kohberger case. It always has been. There's so much we don't know. But things are going to get unsealed. The gag order is going to be lifted. And I think we're going to find out more. Peter, your thoughts on the prosecution getting emotional at the end? Never seen that before. I've seen it plenty of times. I've felt it before. Some of my cases as well, especially as a civil plaintiff's lawyer, where you got to be really prepared and ready to go in and locked in, or else you can really go there if you let yourself. Let me rephrase. The agreement today will be invalid as there is legit proof he did not enter to hurt KG and EC. What does that do to the case? I completely disagree with you, especially because he has admitted to it and pled guilty to it. So I do not think there is going to be legit proof and evidence that's going to overturn this. I just really don't. No proof submitted. Just rehash of the flaky PCA. Explain why the defense asked for the 24th request or evidence. Why now the offer? Legally speaking, I think you're off base. I would disagree with you. I do not think that will ever become an issue that overturns anything in this case ever. Peter, does the Constitution say the public sentiments should be protected in trials, or just truth, justice, and the rights of victims and defendants? Both. Crazy. They can't prove connections, and he just pled guilty. Why? No disrespect mean towards the victims, because he did it. He did it. And again, I think there's evidence we don't know about that was going to cook him. When can a defense attorney talk to the media? After death? Are they still bound to the client after trial? Thank you for following this case since it happened through the arrest, all the listless motions, all the continuances, and to the plea deal. I can say I have learned so much. Thank you so much, Annex. I really appreciate that. There's a couple different things that you asked. So the gag order in this place, the judge is going to talk about when it's lifted. The defense attorney, though, when it comes to the attorney-client privilege, which it sounds like what you're asking when a client dies, that lives on. That is the client's privilege. The attorney can never talk about the case if the client doesn't allow you to. That is always covered under privilege.
Leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd been on that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks him back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrives at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewis and Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport, large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined on the 13th.
Yeah, the selfies and stuff and the timing and what he's wearing and what he looks like, when that stuff started to trickle out, it was like, okay, there's a lot of things trickling out lately in this case where I was like, yeah, that's going to be tough to overcome for the defense. That's going to be tough to overcome for the defense. Peter, I believe myself, the Dateline had the possibility of causing evidence to be excluded because the poison tree doctrine. Do you think it was a possibility? Please have a great time in Greece. You deserve it. I appreciate that so much. I don't think much of anything would have been excluded. It's not fruit of the poisonous tree because somebody leaked and said, hey, this exists, if it wasn't gathered inappropriately. Now, that person could be sanctioned if they violated the non-dissemination order, but that's different than violating Brian's constitutional rights if you were going to, unconstitutionally collect evidence and it be fruit of the poisonous tree. Isn't justice served if the perpetrator pleads guilty and takes responsibility instead of appealing a DP forever? At least we now know he did it. I agree, but again, to the victims, if they don't feel like it is because they don't feel like the punishment is bad enough, that is their prerogative to have that feeling. And I understand it. I get it. Nothing would ever feel like enough, right? So I can't blame them for that. But I think different people have different definitions and different ways that they look at justice being served in a case like this. Mike Easter did some phone work on this case. Can you bring him back to talk about it after the gag order lifts on the 22nd? We'll see if he wants to and if he's able to. I don't want to push in an area that he doesn't think is appropriate to talk about.
Up to the 13th. The state's evidence will show that following Sunday, November 13th, 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicle seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull during the nighttime hours. Agents of the FBI, who assisted immensely with this case, working with the sanitation department back in.
I think a lot of this we had heard before and knew, but there was some new breadcrumbs trickled out. This is definitely not all the evidence they had. I wouldn't say bare minimum. It's just enough for a factual basis, which is what every prosecutor does in a situation like this. Peter, do you think they will continue the investigation into who leaked the evidence to Dateline and we will find out who it was? I think they should, especially if it was a member of the prosecution team or law enforcement. They really shouldn't be doing stuff like that, and it could absolutely affect cases in the future. I think that would be important to look at. Could his change of plea have anything to do with his parents not now having to testify? Mom to the 1 hour call after the M and dad on the drive. Maybe they knew something and he didn't want them. I don't know. I just don't know. I don't know what it led to, right? Anybody's guess is as good as mine here at this point if there's something happening in the background.
In this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court and the public the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it.
The car had been disassembled, basically. That was something new to me as well. We knew that it had been cleaned, that there were cleaning products, but did he like take the seats out of it and like really clean it, like get rid of all the carpet and everything? You know, there were some details there that maybe I had missed it before, but it seemed even more in depth of a clean job than I initially thought.
In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all.
If he's doing that and you're the family, what do you think? Like if I went home and did that, my dad would be like, what the heck are you doing? Why are you doing that?
Own cars, you know, in those compartments in the doors, we try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me.
So again, that was, I think, when people were saying, did he get choked up? Seemed like he did. I don't know. Sounds like he's reading what could have been an opening statement, or is this the usual format for presenting the state's case in this hearing? This is exactly what every prosecutor would do. You have a factual basis. You basically read it to make sure you don't miss anything. If you want to put on for the cameras, you can really, look up and just try to tell the story. But usually you type it out exactly how you want to do it. The defense will agree to it. You send it over to the defense. This is our factual basis. Is he good with this? Is he going to plead? Because if not, then we don't have a deal. So usually you've got to exchange that. It's in writing. You make sure you want to get it right and you read it just like he did.
Mr. Kohberger entered the residence of 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed. And
this is what this person, Richard Art, is getting to. False. They noticed DNA and sent it off to Othram, whom just got a grant from IA. Then the S came in, took it away. Now I ask you, am I lying? So we've been over this a million times, talking about what the FBI did, what rules they broke. We did that in all of the different hearings. The issue here legally, which is what I'm standing on business here, is Brian Kohberger said, yes, I did that. When the judge said intent with malice aforethought, that these were intentional killings with malice aforethought, yes, plead guilty. Yes, I did that. That's all the evidence I need on the record for my proof that he's saying he intended to do this in the legal definition that was read to him, and he understands it and still says yes. So personally, that's all I need. I agree with you. There are still some things that are weird in this case. And the state says, we don't know where the weapon is. We don't know what he intended to do X, Y, and Z with all these people, or what he did when he walked in there, what his thoughts were. And that's just what happens sometimes in these cases when the defendant admits it, puts it on the record, says, yes, said I plead guilty. That's your answer.
Intentionally, willfully, deliberately, with premeditation, and with malice aforethought. Manny Mogen, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
And again, you could hear his voice shaking a couple times. You could definitely hear his voice shaking, and I understand it. 4 young people lost their lives brutally, and he's been working on this for years to get to this moment where he knows beyond a shadow of a doubt at this point, because he said he did it. that he's got the right guy.
Thank you. All right. Based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
The court will find that the defendant understands the nature of the charges and each offense and possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the.
So there's your answer. The judge accepts the plea and it's going to be entered. Think more evidence could come out for sentencing. I don't know about for sentencing, but with the gag order lifted, I think we're going to learn more. I definitely do. The trial wouldn't have answered those questions. I definitely think the issues with motive, what he knew or didn't know, why he did it, things like that, I think there still would have absolutely been unanswered questions, even if this case would have gone to trial.
Matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that
And
accurate?
it's funny, like they're going to waive the pretrial investigation. And it's like, after everything they've done throughout this case, fighting every single thing tooth and nail, they're just like, it's over. White flag. This is what we wanted, I guess, was, a life sentence. We just wanted to get rid of the death penalty and we got it. I don't know. I guess interesting. Listening to him say guilty, so matter of fact, is surreal. I get it. Peter, can he speak at sentencing? He will have usually the judge will allow him to, especially if you're the defense and you ask for him to be able to make a statement. Absolutely, he can apologize. He can say a lot of different things. He can tell why he did it, where the weapon is. He can say that. I wouldn't necessarily expect it. Alice said, my last super chat was criticized for not taking plea on the face value. He's not innocent, but questions are how we get answers. Was he alone? Was this the first rodeo? The plea means we won't be answered soon. Yeah. And this was one of the things that a lot of this wouldn't have been answered necessarily at trial either. Maybe it would have. Maybe some would have. Jurors can pass the DP test during voir dire, but still say no to DP and sentencing or worse, acquit or hang. This outcome equals peace of mind. It's done. I will never see this as anything but a horrible due to some of the family's treatment. They treated them like they don't matter and took the death penalty off the table for them without them knowing. Yeah, but I mean, there have absolutely been reports that some of the families were in absolute support of this plea. So what do you do if there's 4 families, 2 say yes, 2 say no? Prosecutors are put in difficult positions sometimes.
Yes, Your Honor.
The state also.
Yes, Your Honor, the state does not believe pre-sentence investigation is needed given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both
So we're going to be hearing from the victims that want to make statements at sentencing.
the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than 1 full day for sentencing?
I do not believe so, Your Honor. We have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe,
And I like the fact that he said that. Not all the victims are going to see this the same. They have unique perspectives.
that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available.
So before Ann Taylor answers this, you see her look over at Brian Kohberger and they talk, and it sounds like they want to just do this as quick as possible. Just again, all of this is interesting to me in light of how we got here.
Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
This date, I believe, will be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. And we'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor, thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
So he says, any reason why I should not rescind the non-dissemination order at this time, meaning he wants to rescind it. He thinks that's the right thing. Why should he not? What's the point? We're not going to poison a jury pool at this time. It doesn't matter. Let's rescind it. People can talk about the case. More information can get out there. I think he's going to want to unseal some things as well. Nothing that's going to hurt any of the victims of the case, but anything that maybe makes Brian Kohberger look bad that was a public filing, it doesn't matter anymore because he's admitted to doing this.
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through
All right,
sentencing.
I will.
Everybody agrees, all the lawyers at least and parties agree. They think the non-dissemination order should stay in place till sentencing. They didn't give a reason why, but as a judge, if everybody agrees, what's the hurt in letting it stay for, another couple weeks until July 23rd or 24th, whatever day they're doing the sentencing?
At this point, the idea to keep it until
None of them gave a reason, and I don't know the reason why at this point, because the person making this decision is the judge. So you're not going to affect anybody by opening this up. But in an abundance of caution, if I was a judge and the lawyers both wanted something in this situation, I'd probably give it to them as well.
which time it would be sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
I assume that the trial date will be vacated.
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned. All right, please.
All right. So that was it. Any clue why the state would want the gag order delayed? The only thing I can think of is they don't want anything to jeopardize this. Let's just get this finished, get sentencing done, get it over with, get it behind us. Are victims allowed to criticize the DA/judge in their victim impact, and how long are they allowed to speak? Usually there's not a time limit as long as they're not wasting time or going overboard, going off on people. They're absolutely allowed to criticize the DA or the judge or whoever they want to. And as long as it doesn't become overly outlandish or rambunctious or disruptive or, just too wild, they're given a lot of leeway, victims in these situations. Now BK will see himself being studied along with Bundy and BTK in the same classes he took in college. Yeah, I don't know what to say about that. I think the families could have been treated better through this part. That's why I feel it was a bit disrespectful to cry. BK answers are snippy. Yes. Yeah, it was a tough hearing, no doubt about it. A couple of these comments came earlier. They really had nothing to do with this video, so I wanted to save them to the end. Nathan said, wife turned 30 yesterday. Spirits are low. Morale is shaky. She's a hardcore fan, lives for your live streams, requesting an emergency shout out to stabilize the situation. Happy birthday, Gabby. I've got a cousin named Gabby. Love the name Gabby. Happy birthday, Gabby. 30. It's an amazing decade. I'm in that decade right now. Absolutely love it. Thanks for being here. Thanks for hanging out with us. Parrot Dad, will you have Turtle Boy on? I don't know. I just never really knew what the right time would be. I don't want to get into a lot of the situations, or I don't want to go at people the way that he goes at people. I have no problem calling people out. I just like to do it my way. He likes to do it his way. I'm not going to tell him how to do it, right? He runs his channel and does it the way he does it. I think he has brought a lot of good and a lot of light and shed a lot of light and done things that people absolutely would not have done to help shine a light in the darkness that is Ken in that police investigation. He's also done a lot of things that, I don't think he should have done. But again, he's a big boy. He's an adult. He does what he wants to do. But people ask, we have different philosophies and different styles. I'm a big fan of justice, and I think he helped bring justice, and I think that was great. And I know he's going on a lot of channels and saying a lot of things, and people are learning a lot from the different comments and interviews that he's doing. I don't know. I won't close the door on it completely and just say no, but at this point, I don't necessarily have a plan in place or some kind of date. And I know people always, people send me a ton of emails and messages like, oh, he trashed you, or he hates you, or he says this about you. I think maybe he would come on. Maybe he wouldn't even want to come on. I don't even know. But the point is, he has his place in this case. He deserves to be part of the movie or whatever it is, because he's got a big role in it, for better or for worse. And so I'm interested to see how that is portrayed in film or book, for sure. And I get people saying like, oh, you can say no. I know I can say no. I can do whatever I want here. I realize that. Nobody tells me who I have to or who I can't. So for everybody saying, no, you absolutely can't do it, if I want to, I will. Everybody's saying like, oh, you absolutely should do it. If I don't want to, I won't. It's got to feel right for me. I got to always feel like I'm doing the right thing. And when I weigh these decisions, I always try to do the right thing, period. And it won't, if I don't have him on, it won't be about anything that he said about me. That will not be the reason. So weird. He seems almost cheerful. Again, back to Brian Kohberger. Prosecutors work for the state, not families. I understand the families wanted the death penalty, but there is one less killer in Idaho in the country now. I get it. And again, it's a pretty difficult situation. It's a pretty difficult situation to wade those waters as a prosecutor. Peter, question. Are you on the boat? I'm going to be on a boat in Greece, not Lori Vallow's boat. Thank you for putting things into perspective. Made the weird vibe not as weird. Have a great vacation in Greece. Do you think he took the plea so he could keep control of his story and get an emotional victory? He's very monotone. He doesn't want to appear Norm. I have no idea. All I can say is I think he took it because he is guilty. That's it. Can we get another I'm a big fan of Justice shirt? I got the original, but it's fading. I need another one, please. John, that's a John question. We'll have to write that down. All right. That's all I got. I appreciate you guys being here with me. As always, make sure you hit that like button. You're the best. We're still not done. We'll follow this for sentencing as well, but we're closing a lot of chapters on a lot of books here. It feels like with Valo Daybell, Karen Reed, Diddy, and now Brian Kohberger. Kind of wild. All happening right here during the summer. I appreciate you guys as always. You're what makes this fun. Yours what makes it enjoyable. You are what make me learn from this. So I really appreciate that as always. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.